Hey guys, let's take a look at Manson's new motion to dismiss and motion to strike in the New York Jane Doe case. It has some solid legal arguments with a possible fly in the ointment. But first, it's worth noting plaintiff has conceded to Manson's position that the case should not be anonymous. Manson names her as Bianca Elaine, which comes as a surprise to no one, in the very first sentence of his motion. Manson, as you'd expect, first denies the allegations in general, but that's really got nothing to do with a motion to dismiss. A motion to dismiss generally tests whether the lawsuit as filed, as it's alleged, has some fatal flaw right there in its own language. Maybe it fails to allege all the legal elements necessary to state a valid claim. That's often an argument. Or maybe the facts as alleged show the statute of limitations has already run. And that's the argument we have here. Now, Manson notes, as we've discussed, that federal courts for diversity cases generally apply the law of the state in which they sit, and this includes the statute of limitations. So remember, diversity jurisdiction is really about preventing discrimination. It's not about the federal courts creating their own law for car wrecks. That just depends on whether you're in state court or federal court. So the law is pretty much going to be the same whether you're in the state court or the federal court. But you might also remember an earlier comment I made that when you deal with new statutes like this Adult Survivors Act, that the plaintiff is using to revive her claims. You can read it, but you can't really know how the law settles until the appellate courts weigh in, and this gets important in Manson's brief. Because in this case, Manson cites New York appellate cases that say revival statutes, like this Adult Survivors Act, do not apply extraterritorially, in other words, outside the state. The case he cites involved the Child Victims Act, which revived claims, and in which someone who never lived in New York sued someone else who didn't live in New York for abuse that didn't occur in New York. It sounds to some degree like this suit, in part at least. The court said revival statutes are extreme examples of legislative power, and they certainly are that, because they're changing the law retroactively, and they won't be construed ultra-liberally. The court looked at the history of it and did not find that it was passed with the intent to entice people not from New York to come to New York and make it their form of choice for litigating abuse acts that didn't even occur in New York. Now, as I mentioned, that dealt with the Child Survivors Act, not the adult, but the logic is the same, and it seems to me this argument by Manson is a winner. His argument is then bolstered by what is called a borrowing statute, which says that if a non-resident sues in New York for conduct outside of New York, the claim has to be inside both the New York statute of limitations and the limitation period for the state in which the conduct occurred. So if you had something that happened, say, in Texas, and you filed it in New York, you would need to be in time in New York and in time according to the Texas law. If you miss one of those, you're hosed. Again, this is to prevent forum shopping, having people come to New York just to use the court system to sue. Manson then puts another nail in the statute of limitations coffin by noting the Adult Survivors Act does not apply to claims, obviously, where the victim was a minor, and the Child Victim Act window had already closed. We'd already talked about that too. Manson then notes that the alleged out-of-state assaults in 1995 occurred in Texas and Louisiana, and that the statute of limitations is a long run in both of those states. So in Manson's argument, which I think is correct, the plaintiff does not meet either requirement to get past the statute of limitations in New York. In other words, she's not in time in the states where the acts occurred, and she's not in time inside the state of New York, because this Revival Act wouldn't apply to her as a non-resident. Manson says this logic applies to the battery claims relating to the Texas and Louisiana assaults, alleged assaults, and for non-battery claims where the plaintiff first had the right to sue. So, for example, intentional infliction of emotional distress, she's saying that all started at this first assault, and if that occurred in Texas, that's where she first would have had the right to sue. And because she does say in her lawsuit that, this was kind of a continuous conduct by Manson, that he kept her under this spell over the years, culminating in this alleged assaults when she was an adult, Manson says her claim arose at the time and place of that initial incident, if it exists at all, and that's Texas. It's a pretty strong argument. So that subjects to dismissal potentially the plaintiff's claims for a battery for when she was a minor and for the acts outside the state, and also her claim for intentional infliction of emotional distress, even though that strayed into New York, it started in Texas. It's pretty good arguments by Manson. Now, this doesn't dispose of the whole lawsuit if Manson were successful. Plaintiff does allege, for example, assault in New York while she was an adult. So Manson's statute of limitations arguments, they don't cover this. Nevertheless, it does cover a lot of ground, and that's why it's accompanied by a motion to strike. Not an anti-slap motion, just a good old-fashioned motion to strike. Manson moves under Rule 12F, which permits the court to strike redundant, immaterial, impertinent, or scandalous material, if appropriate. Manson refers to the allegations involving minors and the things in the complaint that deal with that, all the child stuff and symbols and things like that, as scandalous. Well, they certainly are scandalous. Whether it's true or not, it's scandalous stuff. Then he says, because the claims based on any acts when the plaintiff was a minor are barred on their face due to time, the scandalous allegations are irrelevant and immaterial to claims of battery when she was an adult. So you see the logic there, which is, hey, if he assaulted her when she's an adult, is what it is. You look at the facts of that. It has nothing to do whether he purportedly had this interest in children or not, because there are no claims, Manson said, that should survive in the suit that deal with any minors. So I get that logic. Manson says striking these allegations narrow the issues for discovery and trial and cites some case law that supports that. So if he gets the claims struck for statute of limitations, I could see him winning this, at least partially. But it's not quite as strong an argument as the statute of limitations itself. It's somewhat derivative. Overall, I think Manson's statute of limitations argument for the things he wants to strike, and that's not all of the suit, okay, it's not, for example, the things that happened in New York, those arguments are strong. Since some of this involves weird New York laws, and I'm not paid to research, but these guys are, we'll see if the plaintiff comes up with something awesome to the contrary. But generally, you can read a brief and see if the argument is pretty strong. This appears so. I think his basis for statute of limitations, to me, that just looks like a winner. I really thought it did before he even ever filed this, because the Adult Survivors Act, it doesn't apply to minors, right? So if you waited too long for that, then you have this problem. I mean, she even puts that in her lawsuit, the Adult Survivors Act. Now, there are a couple of flies in the ointment with this motion to dismiss. If you're a Manson fan, you shouldn't start cheering for this dunk quite yet. You need to see what the ref has to say. For example, the complaint does not say that the assaults were in Texas. However, motions to dismiss usually involve only what is in the complaint. Manson asked the court to take judicial notice that because of the dates, one can know where Manson's performances were at the time. This might not work, though. The court might not agree to take judicial notice of whatever you have to look at, a fan wiki or whatever, to say, yes, he was here on this date. They might not. But you can expect the plaintiff would argue against the court's taking judicial notice of this, even if it were only to delay the inevitable if Manson is correct on the statute of limitations arguments. Now notice even Manson doesn't have complete confidence that the court's going to take judicial notice here, because he says if it doesn't happen, quote, Warner respectfully moves for a more definite statement identifying the location of the alleged incident pursuant to Rule 12E, end quote. Now, I don't practice in New York, but motion by footnote, not sure about that. So I think here he's hoping the court will go ahead and take judicial notice of it, because if you can't dispute it, and if the plaintiff were to choose not to dispute it, you're going to get to the same conclusion sooner or later. But we'll just have to see. The other thing to note, Manson does in a footnote, is that apparently Louisiana has maybe kind of its own sort of revival statute situation going in the form of removing limitations for these type claims. But whether it applies retroactively is subject to dispute and appeal. Currently, it appears it does not. And if it does not, then he's correct in saying that, the statute of limitations has long run on her claim. But if it were to get reversed, then that could change. But even if it did, I think Manson still wins under his argument that the claim has to be timely under New York and Louisiana law. Now, if you feel like he did this and he should be held to account, I understand that. But do keep in mind that it was the plaintiff's decision to sue and she doesn't live in New York. Manson doesn't either. To sue in New York, trying to use New York statutes to capture things that happened in Texas decades ago. That can be problematic. And it is here, as Manson's team has pointed out. So in conclusion, obviously Manson's team is on this case, and they're on it fast. He stacked several issues up: the removal to federal court, the changing the name to the real party in interest, the motion to dismiss, the motion to strike, and the plaintiff has to deal with this either by conceding or opposing each of these issues. And of course, some of that's occurred, but a lot of it hasn't. It will be interesting to see in which issue the court makes its voice known first, though, because I still have my own question on this removal. But if they leave it in federal court, then eventually they'll have to get to the motion to dismiss. If you're Manson, you have to like the proactive defense your team is providing. Having said that, we've all, if you follow these cases, have some experience with knowing that sometimes courts don't give you a ruling when you wish they would, and you may wait a long time. But that's it for now. Thanks, bye.